In Massachusetts, criminal defendants have a right to speak, they have a right to represent themselves, and if the case goes to trial, they have a right to testify regardless of what their lawyer advises. Despite that, most lawyers advise their clients not to speak during any of the proceedings. And generally it is a good idea, and I find it's a good idea for at least two reasons. One, the defendant often doesn't understand the context in which he's speaking. So the defendant almost always, wants to argue the core of the case, whether he's innocent or not. However, most hearings are pre-trial hearings, and they have nothing to do with his guilt or innocence, at least not directly. They have to do with discovery matters, with bail, with probation, and it's just not the time or place to argue the facts of the case. And the defendant often fails to understand that. Another reason is because the defendants are often emotional, and I understand that, right? But those emotions sometimes get the better of the defendant, and he can end up yelling at the judge, the prosecutor, the witnesses, and it just looks horrible. You don't want that to happen. So one way to avoid that is to let the lawyer do the speaking. There are cases when it's not a bad idea for the defendant to speak, especially if the defendant wants to explain to the judge, if the defendant's been through, say, drug rehab or alcohol counseling, or he has some sort of personal situation. It may not be bad for him to, in his own words, explain that to the judge. But it really depends on the court you're in, the type of hearing you're attending, and the judge. All of that should be weighed, as well as the defendant's disposition before a lawyer should say, okay, it's fine, go ahead and address the court.